So this morning, I realized I was looking at the paper. I guess it was Sunday, and we had the ad in the paper about today's topic, and I thought, oh, geez, it's kind of a downer topic, really. Till death do us part. All right, well, y'all knew what you were getting when you came in, okay? So that was the topic. But really, one of the reasons I wanted to cover this, for some of you, someday you'll need this information. Some of you have already been through this. Some of you will have friends that will lean on you as they go through some of these changes. So I wanted to bring this information to you because I have had too many times where I'm sitting in a conference room with a precious client who has recently lost a husband, who is looking at me saying, well, Bill told me I was going to be taken care of. But I'm looking through all the paperwork and there are some real holes. Okay? I hate that meeting. So I wanted to bring some information to you all today so you can hopefully avoid that a little bit. All right. So if you are, anybody in here been married over 70 years? Okay. Over 60. You had a few of those. All right. Well, first of all, that's a good run. Congratulations. Okay. The couple that I have met with that have been married the longest, 76 years. I met with them a couple years ago. They were in their 90s, as you can imagine. They got married the same year that Gone with the Wind, Wizard of Oz, and It Happened One Night all came out at the movie theater. That was 1939. Okay. The great part about their story is that they were young people and they decided that they were going to elope. Okay. So the young lady skipped school to meet her beloved at the meeting spot, where they were going to elope. And you know what happened? She got there. He wasn't there. All right. So in her mind, she's thinking, well, I can't go to school because I'll get in trouble at school. And back in those days, if you got in trouble in school, you got in trouble at home too. And so she thought, if I get in trouble, my daddy's going to whoop me. But he can't whoop a married woman. And she knew that her beloved was on a timber crew out in Miller County. So she took it upon herself to go out there and find him on the timber crew. Okay, she didn't think about him having cold feet or anything like that. She just didn't want to whoop him. So she went out and found him at the timber crew and said, look, we had a plan. We're gonna make it happen or I'm gonna get in trouble. So they come back into town. They were still building the Miller County Courthouse on Laurel Street. Okay. And she said they went to find a preacher to marry them. And the only preacher they could find, and she said it like she spit it out of her mouth, the only preacher they could find was a Baptist preacher. Okay? So they got married. And yes, she told her dad she was now a married woman. And of course, back in those days, congratulations, welcome to adulthood. You're on your own, right? Well, it must have taken, because again, I was meeting with them. They had been married for 76 years. Her husband had become a Church of Christ pastor. They had 3 boys. 2 of the 3 boys had become Church of Christ pastors. Now, their son that was with them that day, who had been their chauffeur, was not one of the pastors. And I looked at him, I said, well, what happened to you? And he said, well, they all got to have somebody to pray about. Okay. So this couple, that so far is my record. A couple that had been married for 76 years. But I routinely meet with couples that have been married for 61, 65. Okay, that's very typical. I did meet with some couple last week. They were in their 90s. They had been married for 44 years. And I was asking about their kids, and well, she's got 4 and I have 4. And I was like, oh, but they didn't get married until they were, in their 50s. So yeah, they had kids but when you've been married that long, that person truly is just an extension of you. And so I get people that come into the office when they've lost a spouse and they're just lost for so many reasons. But my job is to try to help them figure out how to navigate forward from a financial perspective, from a legal perspective, okay? So I kind of wanted to go over some things that I see over and over again and the common questions that I get in that situation. All right. The very first question I get when I have a meeting with a client who's recently lost a spouse is, what's going to happen with the Social Security? Okay, that is the number one question. Because frankly, life goes on. The bills keep coming, okay? And nobody's really sure in that very early time of what's going to happen to that last Social Security check from my spouse, or what can I expect next month, okay? All right, so Social Security. The easy answer is if both you and your husband have already reached full retirement age, then you call Social Security, you tell them, hey, the funeral home, by the way, will make a report to the Social Security Administration to let them know that this individual has passed away. But you'll need to reach out to Social Security, and they will take a look at the benefits that you are receiving versus the benefit that your deceased spouse was receiving. And if both of you were at full retirement age, Social Security will automatically allocate to you the higher of those two benefits. Okay. But then they take away the lower benefit. You only get one Social Security check. This is a shock to many people that they've heard of survivor benefits, but many don't realize that it's either or. I guess we should be thankful that the government allocates the higher of the benefit. But at full retirement age, it's a pretty simple deal. You just report and they will allocate to you the higher of the two benefits. All right. But then there's some, if you're not both full retirement age, then it gets a little dicey. All right, so for many of you, full retirement age is 66. Some younger folks in here, it may be 67. Some of you may have chosen to take Social Security before your full retirement age. My dad took his Social Security, I think, in the same 24-hour period that he could file at the very earliest. Okay? His philosophy was, I've been working since I was 14 years old. Longevity does not run in my family. By God, I am going to get as much Social Security as I can. And it actually, for him, was the right choice because he passed away at 67. So if he had waited, he wouldn't have gotten very much. But that brought home to me this issue. When your spouse filed for Social Security at the very earliest possible time, at 62, if your spouse passes and you are the survivor, then there is something called the widow's penalty that Social Security imposes if your spouse claims Social Security at the earliest possible date, okay? And essentially what happens is the maximum survivor benefit you could ever get from that spouse is capped at 82.5% of their benefit. Okay? So that is a consideration for folks before they retire. Do I take that Social Security at age 62, or do I wait till my full retirement age? If your spouse took Social Security at the earliest possible time, that can diminish the widow's benefit that you would receive for the rest of your life. Okay? The Social Security Administration has looked at this issue. And for many widows, now remember, you get the higher of the benefits, right? So in that situation, for many widows, if they take the Social Security benefit from their spouse that filed at age 62, and they don't take their own benefit, okay, even if they look at it and go, well, my own benefit's higher because of this penalty. If you delay filing Social Security to age 70, you get an 8% raise a year. Okay. So if I have a couple, very much like my dad and my stepmom, Dad took Social Security at 62. He died at 67. Okay. My stepmom's looking at it. She's going to take about a 17% penalty if she takes his survivor benefit. But what we decided to do was she went ahead and took the survivor benefit, took the penalty, and let her own Social Security payment grow. Okay? She didn't claim hers, even though it was a little bit higher. She just claimed his. And then at age 70, she went back, suspended the survivor benefit, and claimed her own benefit, which she had let grow 8% a year until she reached age 70. All right, so what I want you to glean from Social Security, again, if you're both at full retirement age, it's pretty simple, whatever's the higher benefit. But before you call Social Security, that's what people are going to tell you. Call Social Security, there's a 1-800 number. Get some advice about what to claim and when, because it makes a difference. So for instance, in the example where we have a couple that one claimed at the very earliest time, I ran some numbers, and if I have a couple, Paula and Fred, if Fred claimed at 62 and then he later died, when they're looking at their two benefits, Paula looks at her full retirement age benefit, it's going to be $1,500, okay? But she looks at Paul's benefit, the survivor benefit is going to be $1,600. Well, normally we want to take the higher benefit, right? But what we decided to do in this case is we have Paula claim the survivor benefit. It gets a penalty. She's only getting $1,100 a month, okay? But she lets hers grow, and then by the time she's 70, she claims it, and now her benefit is at $1,840 a month for the rest of her life, okay? So, the question is, and this is always the question I'm talking to my widows and widowers, what income do you have coming in, and what is it going to take for you to live? Obviously, if you can't live on $1,100 a month, then you're going to have to take the higher benefit. That's, anyway. But we definitely want to take a look at it. So don't just file because somebody suggested that's what you should do. A nugget that I know we have told you over and over again, the Social Security Administration, it is not their job to tell you how to file the best. In fact, on the very first page of their employee handbook, it says, basically, you are an administrator. You are essentially a secretary. It is your job to do the paperwork that the claimant comes in and requests that you do. It is not their job to say, well, gosh, looking at all these numbers, it would be a good idea if you just took this benefit and waited a couple years and then took this benefit. That's not their job. Now, I do know some very helpful Social Security employees that will do that. But if they don't, if you ask them what's the best way to do this, they are not supposed to give you advice. Okay? They're just supposed to ask you, how do you want me to do it? Okay. So get advice if you find yourself in that situation about how to file and what to do. So first question I get is, what about Social Security? Okay. So things to take away, you're going to get the higher benefit generally, but you only get one check. The next question we look at is, what about other retirement income? I want to encourage you, if you haven't looked at your paperwork for a while, one of the issues, many people think they elected a survivor benefit for their retirement to go to their spouse should they die. They think they did that. But then when we dig into the paperwork, when that's happened and the spouse is now deceased, turns out they didn't. Okay? And this whole time, this couple has talked about, if something happens to me, then, I've already put you as a survivor on my retirement, and you're going to get 50% of my retirement from the plant, and everybody thinks it's going to work great. However, about half the time when I'm visiting with a widow or widower, we realize that survivor benefit was not elected at the time of retirement. And sometimes there's a couple of good reasons. I've had retirees say, you know what? I didn't want to take a reduction in my initial retirement benefits. I wanted to have plenty of money while I was younger in retirement and healthy enough to go do stuff. Okay? So they did not elect a survivor benefit because it would reduce their initial retirement payments. And so sometimes we kind of forget what we put in that paperwork. And it's very shocking to a widow to realize that she is not going to get any of a retirement because the survivor wasn't elected. Now, that is an election you typically make at the time you retire, if you have that type of retirement plan. So if you're already retired, that election has either been made or not been made at this point. You cannot go back and change it because typically they're going to calculate your retirement based on that election that you made on your paperwork when you retired. They've got actuaries and accountants figuring all that out. So you usually cannot go back and change it. That's okay. All I want you to know is, what is your election? Okay, let's not be surprised. If you elected not to have a survivor benefit, then maybe you should adjust some savings now to put a little bit more of that money that you're getting back. If you elected not to have a survivor benefit on retirement, well then we need to be looking at expenses. If something happened to you, how would we fund the household? Okay, we just need to know. So I would encourage you to look at that. The other source of monies, because money's the big topic typically something like an IRA or a 401k rollover. So that's the third source of money that we see. Social Security first, some kind of retirement or pension plan second, and then we're looking at 401ks or IRA type rollovers. If you are a spouse, you must be listed as the beneficiary on your spouse's IRA. It is a requirement of state law. I have had a client or two who's tried to go in and change that. But the way the law works is you can change it to somebody else, but you have to get your spouse's signature. So I've had a couple that decided it wasn't worth asking the spouse. So if there's an IRA or 401k out there, you as the spouse should be the named beneficiary. If you are, you will have some options to roll that over into what we call a spousal IRA. It's no big deal. It's just some paperwork, okay? That IRA, Yes, you pay tax on it just like you would as you pull it out. If you're over age 70 and a half, you're going to have to take those required minimum distributions. Okay, but that paperwork, you just get it in and they allocate it into your name, and now you're the boss of the IRA and you can take withdrawals and do whatever you need to do. The paperwork can be a little daunting. We help a lot of folks just get the paperwork done. What box do you check and where do you sign, So those are the three sources of income and money that typically a new widow or widower is going to be looking at. Okay, so those are the first category of questions. What to do about the money? Second question that comes up is, well, do I have to probate this will? Okay, if there is one. We hope there is. That is not an easy answer. Of course, we're in Texas and Arkansas, which means we have two totally different sets of laws. Let me just say this. If you are in a second marriage or a blended family, you should probate the will always, always, always. Most lawyers will give you that answer, it depends. Well, if it's a blended family, that is you must probate the will. I don't care what your friend in Sunday school says, that they didn't have to do it. Because both Texas and Arkansas give rights to children that are not of that marriage. Example, I had a couple in Texas, husband and wife, they've been married 26 years. He passed away in his late 50s. His wife, they had basically raised their children together. So this was not a, crazy late life marriage. This was a family, okay? The husband's will said, if I die, everything to my wife. And if we're both gone, then split everything equally between our children, okay? The wife went to an attorney in town and asked, do I need to probate the will? And the attorney said, no. Okay, fast forward 5 years. The wife has now decided that the marital home that she shared with her husband has become too much. There's a yard, it's getting older and needs more maintenance. There's not really a man around the house to take care of all those things. So she's decided she wants to sell the house. All right, so she decides that the house needs a little bit of updating, some new tile, things like that. So she goes to the bank to get a home equity loan to do some remodeling, goes through all the paperwork, and she's getting ready. The bank says, come in to sign the closing papers and we'll get your home equity loan set up. She goes in, and then the banker asked her, well, are his kids coming in to sign? When are they coming in? And she said, well, what are you talking about? He had 3 children. And he said, well, they need to sign as well because there was never a probate on the will and the house was in both of your names. So, and she said, well, he left it all to me. And he said, well, it's not how it is. So anyway, she said, well, I'm sure the kids will be glad to sign off. Y'all know where this is going, right? It's been 5 years. And there was no discord between these folks. But, you grow apart. And so when she called the kids to say, hey, I'm getting ready to sell the house, but I need to do some updates. Do y'all mind signing off? I mean, I'm covering the loan. I'm going to pay it when I close the house. They were like, we're not signing nothing. And when are you going to sell that house? When am I going to get my check? Okay. And so she ended up coming to me. I actually reached out to the attorney that initially told her that not to probate the will. The attorney would never return my phone calls. And I believe that a bar complaint was made against that attorney. If you're in a blended family, then the answer to the question of should you probate the will is yes. Okay. It's going to cost you some money. But if that lady had spent the $2,000, $3,000 to probate that will, then everything would be in her name. She ended up getting a loan, did some repairs. She sold the house. She got half the proceeds. The other half, the title company wrote checks to the other 3 kids. Okay. So that was part of her security in her retirement, that she was going to have the equity in that home to move to something else. So that was cut in half. So, all right, but what if you're that couple that's been married for 76 years? Are we going to have to probate that will? Well, now I'm going to give you the lawyer answer of it depends. I will tell you, as a general rule, if I'm in Arkansas and you've been married forever, and that's the only marriage you ever had, nobody has any other kids anywhere else, if all you own is a home and you got some money in the bank or in investments, then most of the time we do not have to probate the will. Because in Arkansas, your house is owned as tenants by the entirety, which is a special ownership that only married couples can have, which means that that house automatically becomes 100% the survivor's home. We don't have to do anything, okay? And if all the other assets, just money in the bank with joint owner with right of survivorship, or pay on death or a beneficiary, then we don't have to probate anything. Easy breezy. Okay. On the Texas side, mostly similar, community property state. If you've never had a marriage or other kids, then generally we don't have to probate the will. Although I'll tell you this, sometimes, even though we don't have to probate, we want to probate. Okay, now I know what y'all are thinking. Those dang lawyers, they're just always trying to figure out how to get a little more money out of you. All right. Here are a couple of times that we want to probate the will, even though we don't really have to. Number 1, if there is a lot of debt out there, we want to probate the will. Because when we probate the will, we are able to extinguish debt that was run up in the name of the deceased person, okay? I had a case this past year, husband and wife. Husband was into all kinds of motorcycles, cars, campers. Everything had a loan on it, okay? We ended up probating the will so we could deal with the creditors. Do you still owe them the money if the debt was incurred during the marriage? Yeah, you do. But when a spouse dies, we get to take a lot off the top for the survivor spouse. There's a family allowance. They can't touch the homestead. There's all kinds of benefits for the surviving spouse. And then, of course, what I do is I call up the creditors and I say, hey, what will it take for this to go away? Okay? And a lot of times, because we're going into an estate, we can actually settle that debt for less than dollar for dollar. Okay? But we have to get into an estate mode to be able to do that. Okay, so that's a reason to probate, is if there's some debts that we want to deal with and extinguish. Another reason to probate in Texas is in Texas, we now have a law on the books that says the last will and testament that you wrote is not the final word. Okay, now you're dead and gone and you left your will behind, but in Texas, I can now take that will to the courthouse and I can make some suggestions to the judge of how we would like that will to read, but it doesn't read that way. Okay, so you're thinking, wait a minute, that's my final word of who gets my stuff when I'm dead. Why would I ask the judge to change it? The number one reason we are asking the courts to reform a will is because a spouse is left behind that is incompetent, incapacitated, disabled. And if the will that I have is one of what we call the sweetheart will, this is me and my wife, and if anything happens to me, I want everything to go to my wife. And if she's gone, then I want everything to split equally between the kids. We call that a sweetheart will. Very standard, very typical. But if that wife has a disease process like Parkinson's, Alzheimer's, and she is now in need of a caregiver because you're gone, okay, then the fact that you just left everything to her is going to destroy her ability to get assistance. Okay. This might. So those are the times that I take your sweetheart will to court and I say, Judge, husband's passed away. He provided everything to his wife. We would like to put everything, instead of directly to her, we want to put everything into a special needs trust for her sole benefit. Okay, so we're still making sure the wife gets the 100% benefit of that will and that property. But we're doing it in such a way that she's going to be able to get some assistance and some nurses coming into her home. And we're doing it in such a way that the government is not going to be able to come back and take everything. Texas is one of the first states to allow us to reform wills like this. I have yet to have, we're not reforming wills to include the black sheep of the family that you disowned, okay? We are doing it to preserve your estate for the purpose that you intended. Because the bottom line, there's a lot of what I call everyday lawyers out there that will do you a sweetheart will, that can represent your niece in a divorce, that could defend your nephew from a DWI. I'm telling you, your sister's kids are terrible. But they don't understand the intricacies of providing for people with disabilities or as they get up there in age. Okay, so the question of should you probate the will, that's the next thing that comes up when I'm visiting with a spouse. And that answer is blended family, yes. Not a blended family, maybe. Okay, but I will tell you this, when you and your spouse are both gone, for the most part, when your property passes to your kids, these days we're almost always having to probate because we've got real estate title and things like that to pass on to the kids. And all right, so third topic that is often covered when I visit with a surviving spouse is they now want to redo their estate planning. They ask me, I need to update my will, my powers of attorney. I am, depending on the person, I discourage people from making big decisions immediately. Now, if your spouse was your power of attorney and you don't have a backup, then we probably need to talk about that and go ahead and get that in place. But I have seen, when someone passes, it's a very emotional time. A lot of times I will have adult kids coming in, and they are now worried that mama's going to give everything their daddy ever had away, and it's not going to be to them. So they got to get it now. Okay. So I try to encourage that client sitting in front of me to not make any big decisions. It's one thing to give away, daddy's 30-06 that, you're not interested in keeping and you don't know anything about. But I have had kids come in and really kind of like locusts. They just want to, get everything in the estate that they feel like they deserve, that they want to get their half is what I hear them say. So I don't want you to make those kind of big decisions. The other decision point, though, is you're still here. You've got a life to live. Maybe that spouse for 40, 50, 60 years is gone. And ladies, most of my ladies will remain single for the rest of their lives. Sometimes maybe it's out of respect for the memory of their dearly departed husband. Sometimes it's like, I'm not doing anybody else's laundry ever again. Okay? However, my gentleman, let me tell you what happens when a wife passes and there's a gentleman. I call it the banana pudding brigade. Okay. In fact, when my dad retired, he lived in this retirement community in Florida. And he used to say that when a wife passed, it was a traffic jam with all the golf carts arriving at the widower's home who needs to be comforted, and everybody's bringing a banana pudding and a chicken casserole. Okay. Although I will say, in my 20 plus years of law practice, it is much more common to see a gentleman remarry. These guys, I guess they want somebody to do their laundry. I don't know. But we're social creatures. My ladies tend to be satisfied with hanging around their friends and all that. The gentlemen, I think they like a little, admiration from the ladies. And so they often will remarry. So one of the other things to think about if you're a married couple today is, how much effort do you want to put in protecting one another from the new companion that comes into the survivor's life? Okay. We're always trying to balance having you have complete 100% control of everything you've worked hard to earn and save and what you have to show for your lifetime. We want you to have that 100% control. But I will tell you that people can come into your life and manipulate you, especially as we get a little older. And so I have had clients that will come in and say, husband and wife, and maybe the husband's just kind of been the hard one, but the wife, boy, she believes every story that everybody tells her. And so the husband's really concerned that if he's out of the picture, that she will, out of the goodness of her heart, that he just loves about her generous nature, but that she will actually damage herself by, giving away too much, being manipulated. I also have couples tell me that there's a kid. Okay, and this is my forever married couple. Well, I feel like if something happens to me, Barbara is going to be on Joanne's front doorstep, and Joanne can't say no. And Barbara, our daughter, is going to, just with her sad stories, get everything. But then once the money's gone, daughter's going to be out of the picture, and I'm worried that my wife is going to be left impoverished. So as a married couple, you have to balance and think about 100% total control to do anything you like, including give it all away to the new companion or paying the probation fees for the new companion's kid, or put it in trust in such a way that is very restrictive on the survivor. Okay? That issue is very personal to each family. I don't know what the right answer is for your family, but you do have legal ways that you can make it more difficult for a survivor to give away the marital estate. There are ways to do that and still provide for them. So that's another decision point that before you face that issue of losing a spouse that you would want to look into. If you've lost that spouse, then as we look into making further estate planning for you as a single person, we may also be mindful of if there's a companion or some people that don't have your best interest in mind that we need to protect you from. So I say all the time that you as a group, check on your friends. Sometimes, get a little nosy. We don't get into each other's business a lot, but I find this group to be, they look out for each other, and I appreciate that. And so I encourage you to continue to do that. So if you lose a spouse, don't make any major big decisions immediately. Get some advice about if you're not at full retirement age, if both you and your husband were not at full retirement age for Social Security, get some advice before you run down to the Social Security office and just file a claim. And then it's going to take some weeks to gather up insurance policies, retirement plans, IRAs. We need to look at the will, see what's going on there. And so it is a process. So anyway, any questions about this particular topic? Yeah. Yes, sir.
Is this counting Social Security that you started out on? Question.
Yes.
Okay. My wife's not qualified for any Social Security, and if I should die first, will she get my entire Social Security?
If she's at full retirement age or above, yes.
Okay, she is.
So the question is, if she's never qualified for any social, now was she a teacher?
She was a secretary with the school district.
They still have the windfall elimination provision, I believe, on any, so you all, my teachers, y'all are very familiar with the fact that you don't get Social Security if all of your retirement is vested into a non-Social Security participating retirement program, and we call that the windfall elimination provision. So that still comes into play. I am not the expert on that. A gentleman named Devin Carroll here in town is the guru on educator issues with Social Security and windfall elimination provision. So it's good to look in to see exactly what would likely happen based on y'all's ages and what you're getting right now. That way, as you can prepare, because that's another issue we see is people aren't prepared for a reduction in monthly income because your expenses don't automatically go down. And so it's good to get informed now. So, all right. Yes, ma'am. That is correct. So the question is, she's a civil service employee. She's been told she's not eligible for her husband's Social Security. Yeah, no. We can talk about the political decisions that have made. I don't know if you know that Senator Cruz has introduced a bill that will eliminate that windfall elimination. So he introduced that bill a couple of weeks ago. I don't know if he was motivated by the fact he's in an election right now and he'd like some teacher votes, but I'll take it regardless of how it comes. So anyway, so that is a bill that has been proposed. So if you're a Texas person, maybe you should jump behind that. All right, another question? Yeah, yes, sir.
Now, say, 45 years ago, you did all this Social Security thing, and you felt it was okay, but now, then you feel like now that there could have been a mistake on it or something. You're saying you can't go back and check that out again.
No, the question is if you filed for Social Security and you can't go back and change a mistake, yeah. That's generally accurate. For instance, the reason the example I gave where someone could go back, they could claim a survivor benefit and then come back later and claim their own benefit because they've let it increase. An inspector general who was investigating the Social Security Administration found that widows and widowers had been rooked, I guess you'd say, out of about $130 million worth of benefits because they didn't file in the most optimum way. And the inspector general suggested that Social Security clerks be responsible for telling people how to file the most optimum way, but we're not seeing that. So that's how a lot of that came up. And I'll take another question. There was one over here. Yes, sir.
Yeah, it's not about Social Security. I have a friend that passed away, wasn't married. He just wrote on paper what he wanted and had it notarized. How does that stand up?
Okay, so the question is, he had a friend that just basically did a handwritten will that, if he dies, this is what he wants to happen. How does that stand up? And you said it also was notarized.
He has property.
He has property. In both Texas and Arkansas, A will that is written completely and totally in your own handwriting, we call that a holographic will, is a valid will and can be probated and can pass title to property.
So it needs to be taken and probated?
It will have to be probated because a judge has to look at it and accept it.
So nothing can, in other words, if he says, blah, 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 gets this, blah, 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 gets that, they cannot get that? Or?
Well, so the question is, can a beneficiary get property if it's not probated? You know,
They cannot get the property?
if it's furniture or something like that, that can walk off anytime. I mean, that's not really an issue. But if something has a title, such as a vehicle or a deed, then that will have to be probated for those beneficiaries to have the full legal rights to that property. When you have a holographic will, someone has to come into the court and testify that this is your handwriting. Okay, I have had a lot of clients who said, well, I had my granddaughter write out my will. I told her what I wanted and she wrote it down and then I signed it. Okay, that's not a holographic will. That's in somebody else's handwriting. And you signed it. How do we know granddaughter didn't just write it out and say, oh yeah, grandma put everything in here you wanted, sign, okay? So that holographic will can be probated. It is valid to pass title.
Well, now, I was involved in this in a way with a friend, so they kind of being asked me.
Yeah.
So I went in and typed it all up.
Yep.
It's not in the handwriting, and it was notarized from the fact that I typed up.
Okay.
And kept, so it's not in a handwriting.
Anything that is typewritten has to be witnessed by at least 2 people. Yeah. So a notary could count as one. Then we've had that happen. I've had somebody who's had 1 witness and a notary, and we just count the notary as the second witness. But they do have to sign together. All right, this is my last question.
Does that have to be notarized if it's a handwritten will?
Question, does it have to be notarized if it's a totally handwritten will? No, it does not. As long, totally in your own handwriting. So I have people all the time tell me my handwriting's bad, I have Parkinson's and I shake a lot. I don't care. If it's totally in your own handwriting. We actually probated a will that was written on a cocktail napkin one time. It was a professional that was going on a ski trip and he just decided at the last minute, while he was sitting at the bar before he hit the slopes the next day, he wrote out something on the cocktail napkin. We probated it. There were still issues, but that part of it was valid. So anyway, thank you so much.
Thank you, Lisa. You did a great job as usual.